Chairman, you are live.
Excellent. Well, good afternoon, committee. Welcome to another exciting day of corporations. Today we have two bills up before us, Senate File 36 and Senate File 62. Barb, if you would call the roll.
Representative Blackburn. Here. Representative Clausen. Here. Representative Clifford. Representative Duncan. Here. Vice Chairman Air.
Here.
Representative Hunt. Here. Representative McGuire. Representative Roscoe. Chairman Swanitzer. Thank you.
All right. It's great. We're all here for once, including me. First up, yeah, I know apparently I missed a lot of fun on Friday for most of it, I hear. Senate File 36 will be the first up. For-profit public benefit corporations. It's brought by the Select Committee on Blockchains. I don't know, Mr. Kaufman or Representative Olson. You can both come up if you'd like. All right. Whichever would like to present the bill to the committee, proceed at your convenience.
Thank you, Mr. Chairman, and we're gonna tag team this if that's all right with you. So I'll give just a little bit of brief opening remarks, and then I'll have Mr. Kaufman give some opening remarks, and then I'd like to walk through the bill with you so I can get some good practice with it, Mr. Chairman. And but we'll both be here to answer questions. So this is an engrossed bill. And when I walk through the bill, I'll show the change to the committee. This is a for-profit public benefit corporation law. And I want to define what that really is, outside of course, the bill itself. Let's just talk about it in a real general perspective. And I think one way I like to look at it is I start with what it's not, and then I work into what it is. So what it's not is a nonprofit. That's key. It's not a nonprofit or a charity or a hybrid of both. It's a hybrid of something else, which is what it is. It's a hybrid of that nonprofit and a corporation. That's the way I like to think about it. It's essentially a corporation that has a balance between a pecuniary interest, profits to its shareholders, and some public benefit. And that's what it is. So then the next question is why? And there's some legal reasons why, but I want to give you the non-legal reason why, just real simple non-legal reason why. And I should back up and say, and I'm sure Mr. Kaufman would have a lot more information on this as well, but Delaware has what they call B Corps. So that's essentially what we're talking about, benefit corporations, this whole other class of corporation. And so one of the whys, of course, is to keep us up to speed and in competition with Delaware. Always, we can finally claim the crown for all things corporate and company-wise, management and formation. But the main why that I like to think about is simply what it does is allow for a corporation to exist, again, for profit. It's not a nonprofit, but it allows it to exist for profit and have a strong message of what it believes in that is a public benefit, because the law requires that to be in its articles, whatever that public benefit is, because it requires it to provide notices to its shareholders and notices essentially to the world on why it does what it does. I see that as the number one reason, that if I want to have a corporation, that I want to provide a living for myself. Of course, if I'm interested in that company, now I'm a shareholder, that I want to obtain or provide some money for my living and provide for my family. But at the same time, I want to make it really, really clear that my corporation has a purpose that goes beyond the boilerplate language that you find in almost every corporate article of incorporation, which is for any lawful purpose. That's what you normally see in a corporation. But this statute requires a for-profit public benefit corporation to specifically say what it is that it's going to benefit the public, what it stands for. And I think that's a unique opportunity for a corporation. So that's those are just my intro comments on the legislation. Of course, I'll walk you through it, but any intro comments from Mr. Kaufman, who does serve on our select committee?
Go ahead, Mr. Kaufman. Welcome.
Thank you, Mr. Chairman. My name is Matt Kaufman. I'm an attorney, partner with the law firm of Hathaway and Coons here in Cheyenne, and also a governor appointee to the Select Committee on Blockchain. Mr. Chairman, my introductory remarks about this would be pretty straightforward, and that is one of the reasons that this legislation becomes so important is a lot of people don't realize that when you are the director of a corporation, you have obligations and legal duties that exist beyond just statute. We have common law duties that have been adopted by almost every court in the country. One of the most famous cases in this country is something called the Revlon case, stemming from the Revlon makeup company. The Revlon Doctrine stands for the proposition that when you are a director of a company, your first duty to the company is to maximize shareholder profit. So if you take action or a vote as a director that doesn't maximize shareholder profit, you can actually be held liable for that. And there's long-standing lines of case law in this country on that. So one of the outgrowths of that was the Public Benefit Corporation. What if an entity wants to be for profit, but the directors want to take into consideration in fulfillment of their duties something that doesn't necessarily maximize the shareholder profit? And that's where the Public Benefit Corporation comes in. It allows an entity to have a dual purpose. We're both going to be for profit, but we're also going to have some greater good or cause at our core that will allow the directors to conduct a balancing of those interests and make a decision that's best. Two examples I'll give really quickly before we go into the bill. There's a very famous company, the name is escaping me at the moment, from Massachusetts, and it's a bread company. They manufacture bread. The company has made it a corporate purpose that they want to only purchase American wheat. And so their promise to their shareholders is, look, we're only going to buy American wheat. We're only going to source American wheat. If that hurts our bottom line a little bit in doing so, so be it. That's our corporate decision, and that's what we're going to do. I came to this bill, quite frankly, Mr. Chairman, from a young woman over in Laramie at the University of Wyoming that developed some remarkable software that helps organizations detect if there is sex trafficking happening in their organization. She tried to make it as a nonprofit, but was having a really hard time licensing the software and raising money. This would have been her go-to entity because she could be a for-profit entity, but recognize that software and the actions that she takes in rolling that software out through her company might not maximize every bit of profit. So that's the legal outgrowth of an entity like this.
All right, Mr. Chairman, if there's no questions on the intro, I'll walk through the bill.
Okay.
So nothing happening on page 1. Page 2, obviously the short title, definition of the for-profit. And I think we both really spoke to that in terms of, you can see right there on line 18, page 2, towards the end of the line, balance. And that's really it. A for-profit corporation is obviously organized under the laws of the state of Wyoming, and it's managed in a manner that balances the pecuniary interests of the stakeholders and the public benefits identified in its articles of incorporation. Page 3, public benefit provides, we provide a definition, and I think you go down to the bottom of that definition, lines 5 through 7, including, it's not necessarily limited to, and then here's a list of what we're talking about. What could it be? It could be something for artistic purposes, charitable purposes, cultural, economic, educational, environmental, literary, medical, religious, scientific, or technological in nature. And it doesn't, if you go back up to the top half of that definition, just to clarify, I suppose, the public benefit could mean a positive or negative effect on any of these categories. So it doesn't mean that you just have to necessarily promote a particular activity, but maybe not promoting an activity maybe for a public benefit as well. Bottom of page 3, 17-31-103 is just the applicability. Make it really clear that our existing corporate law, so Wyoming Business Corporations Act, does in fact apply to the for-profit public benefit corporations. If the bottom of the page 3, subsection B, all that's saying is that if you convert, if you're an existing company, you can elect to convert, et cetera, to a for-profit public benefit corporation. If you do that in accordance with the statutes and how you do that, you're subject to obviously the Wyoming Business Corporation Act and what we're putting in place in this law. That takes us over to page 4. And 17-31-104 are the contents of the articles of incorporation. So what we're going to require be in that filing doc, in that initially filed document that you're going to place with the Secretary of State's office. You have to identify what your public benefit is. That makes sense. And then number 2, you have to state that it is a for-profit public benefit corporation. So it's going to be clear that that's what it is. Subsection B talks about a naming convention. It's a may option to include the words for-profit public benefit corporation or some derivative of that, PBC, public benefit corporation, et cetera. That's an option. If you don't elect to go through that naming convention, you just want to call your corporation the Smith Corporation or whatever you want to call it. The corporation shall, bottom of page 4, line 22, prior to issuing any unissued shares of stock or disposing of treasury shares, it's going to provide notice to any person whom the stock is issued or who requires a treasury shares that it is a for-profit corporation. And the notice has to include what its beneficial purpose is. Page 5, midway through, 17-31-105, nonprofit stock corporations. This just says that a nonprofit can't be a constituent part of any merger or consolidation with a for-profit public benefit corporation. Remember when I started out my opening remarks, start with what it's not. We're not talking about nonprofits. We're talking about something completely different. And I think so we want to keep a clear distinction between those. Stock certificates, bottom of the page, notices regarding uncertificated stocks. And that substance appears on page 6. This is the substantive change I'll get to that occurs in creates the engrossed version that we have. So the change that the Senate made. Number 1, any stock certificate issued by a for-profit public benefit corporation has to conspicuously, obviously note that the corporation is a for-profit benefit corporation. And then this is the part that's added, lines 4 essentially down to 8 at the end of the period. So you're going to provide in your notice that this is in fact a for-profit public benefit corporation and that the directors of the for-profit public benefit corporation are required to balance the pecuniary interests of the stockholders and the public benefits identified in the corporation's articles. So everything we've been, I guess I could turn it over to my good co-chairman from the Senate. If you have a question when you do about why the Senate added this language, but just in looking at it from, I wasn't there, but looking at it in my perspective, it seems pretty obvious that we really want to drive home the point that everyone involved, whether you are, the former or you are simply a stakeholder who comes along later and acquires an interest in the company, we want to make sure that everybody understands that it is a for-profit company and that you understand that, to Mr. Kaufman's point, what the director is balancing his or her, or directors are balancing their fiduciary duties with for profits and for that benefit. Bottom of page 6, or halfway through, I should say, 17-31-107. These are the duties of the directors. And this is what Mr. Kaufman was speaking to. So what is the duty? We're going to spell it out. You have a duty to drive profits and balancing that pecuniary interest, the driving of profits of your stakeholders with the public benefits identified in your articles of incorporation. Bottom of page 6, a director, we're going to clarify that a director for a nonprofit shall not, by virtue of simply it being the public benefit corporation and having the duty of to the public benefit corporation, Mr. Kaufman, remind me, what is this subsection B?
Yeah, Mr. Chairman. So the purpose here is that it doesn't, by virtue of being a director in a public benefit corporation, it doesn't create a duty necessarily to the public, just to those shareholders and stockholders, recognizing that you have to balance that duty that's owed to the public. That makes sense?
Yeah. Perfect. Subsection C, a director's ownership of or other interest in the stock of the for-profit public benefit corporation create a conflict of interest in the part of the director with respect to the director's decision-making, except to the extent that the ownership or interest would create a conflict of interest otherwise. So obviously that director or directors may have, and likely do have, individual interests in that public benefit. It's why they became a member of the corporation. And so that by itself doesn't create the conflict unless it would have otherwise created a conflict under existing law for that director.
Can I, just a quick question that I'm not sure was mentioned. Is this boilerplate language? I mean, 30 some states have this. Are we, anything that's not part of, there apparently there's no standard model act, but anything that's not generally accepted in other states, if you just highlight as you go along.
I'm sorry.
Sure.
Yeah, go ahead. I was going to say, I think it's 35 states, I think maybe.
Yeah, Mr. Chairman, approximately 36-ish states have some form of the public benefit corporation. There is not a model act the same as there is for Model Business Corporation Act. This act is based on Delaware's largely. Colorado has a statute that's also very similar as well.
And I think to your point, Mr. Chairman, when I get to page 10, 1731, 109, I do believe that half of that statute is essentially lifted from Delaware. I do think we made some changes to that, and maybe Mr. Kaufman can more specifically address that, or maybe I'm thinking of something else.
Okay, sorry, didn't mean to stop you. Go ahead.
You're all right. Page 8, 17-31, 108, periodic statements and third-party certification. So these are going back to the notices I was speaking to earlier. A for-profit public benefit corporation has to notice, and every notice of a meeting to its stakeholders or stockholders, sorry, it's going to say the following. It's a for-profit public benefit corporation formed pursuant to this chapter. And no less than annually, so once a year, which it could provide more than once a year, of course, a statement of the promotion of the public benefit identified in the articles, and it has to include the following. And this list that you see over on page 9, really what were the objectives of the board of directors, the standards, an assessment of the corporation's success in meeting the objectives and promoting the public benefit and interest. The articles of incorporation.
Representative Ayer seems to have a question. Go ahead.
Thank you, Mr. Chairman. This statements and third-party certification that's included in this section here would seem to cover what was covered in the addition to the stock certificate earlier by the Senate amendment. And to me, it doesn't seem like the Senate amendment's necessary because there's plenty of notification in this section here. Is that, am I thinking clearly? Is there a good reason why the stock certificate should have that notification as well?
Maybe a good
It
time.
seemed to me like we're covered here.
Yep, maybe a good time for my co-chairman to explain that Senate amendment if he can.
Hi, Senator Rothfuss. Did the Senate do brilliant work to this bill?
Mr. Chairman, as always. Mr. Chairman, this was raised by one of the members of the Senate Corporations Committee as a means of making sure that it's clarified during purchase, in theory, of the stocks, whereas a stockholder meeting would take place obviously at a different time. So the idea is to make sure that at all steps where you might be engaging with that institution and having a financial investment, that you would have the benefit of understanding that those pecuniary interests would be balanced against the public benefit of the corporation. So I'm not entirely certain whether or not it would be critical and that it wouldn't make itself evident, but that was the interest of the member, and I had no objection. I don't see it as detrimental, but potentially clarifying. Thank you, Mr. Chairman.
Okay. Go ahead.
Mr. Chairman, Mr. Kaufman deals with corporations on a much more daily basis than I do, but I would wonder maybe the reason why you double up on the notices is that, and not all of us are as, not all of us pay as much attention to both to the notices as stockholders, and then not all of us read our certificate, just kind of gets filed away. So maybe that's the reason for it, is just trying to cover multiple bases because not everybody reads all of that.
Yeah, Mr. Chairman, if I may, that was exactly the reasoning. Is most corporations these days don't even issue physical stock certificates. Those are kind of going away. So obviously, if they're issuing stock certificates, you got to put that notice in there. But otherwise, we're relying on that third party, that annual certification.
Mr. Chairman, almost through here on page 9, subsection C, the articles of incorporation or the bylaws of a for-profit public benefit corporation may require the corporation to do any one of the following. So now I think I mentioned one of these earlier. I think this is the one where you can, yeah. So we require the annual notice, of course. This is simply saying you can do that as much as you want. You can have as many of those notices as you want. Make the statement described in subsection B of this section available to the public. So that's the notice, right? That Representative Ayer is talking about. You can put that up on your website, or nothing prohibits you from doing that, I suppose, if you want to. I think that would have probably have been maybe that. I don't know that we had to write that in to allow for that to happen, unless the statute said you couldn't do it. I would have argued that you could do it, but we're going to specify that you can do it. So, and then use a third-party standard in connection with or attain a periodic third-party certification addressing the corporation's promotion of the public benefits identified in their articles. Okay, bottom of page 10 has 17-31-109, the enforcement. So how do you enforce it? So we've been talking about balancing, right? Got to balance the pecuniary interest of the company with the public benefit. Who gets to enforce that? Any individual derivative could have an individual action or derivative action of any type. But it cannot be brought unless the plaintiff in the proceeding owns individually or collectively, as of the date of instituting the proceeding, at least 2% of the corporation's outstanding shares. Now that I remember, I hope I remember right, is lifted from Delaware's statute. The part I was unsure of is the second half of that, Mr. Kaufman, or in the case of a corporation with shares listed on a national security exchange, the lesser the percentage of shares of the corporation with a market value of at least $2 million. I'm not certain that came from the Delaware statute.
And Mr. Chairman, I would just add that both of these provisions appear with a majority of the states that have the public benefit corporation.
So somewhere in the statutes we looked at, I get you. Okay. Last page 11. No effect on other corporations. This statute 1731-110. And then I think that's pretty straightforward. And then section 2, just the effective date, July 1, 2021.
All right. Representative Roscoe, go ahead.
Thank you, Mr. Chairman. Two things. The first one is how is it taxed differently than either a for-profit or a not-for-profit corporation? And then the second thing is, how does it tie into the blockchain? Specifically, is it with our looking to the future for banking and stuff like that? Sure. Thank you, Mr. Chairman.
Mr. Kaufman.
Mr. Chairman, thank you for the question. In response to the first question, as far as Wyoming is concerned, since we don't tax entities, there's not going to be a difference. For IRS purposes, they're still considered for-profit entities and are taxed just the same. So there's no distinction from a for-profit entity for taxation purposes. With respect to your second question about how this ties into blockchain, the direct answer, Mr. Chairman, is it doesn't necessarily. This is just another entity type that exists in, again, about 35, 36 other states. My observation would be, I work a lot with venture capital and private equity companies. There's definitely a trend we're seeing nationally of folks that want to invest in all types of what they call impact investing. That might be, investing in entities because they consume American wheat, or they utilize, Wyoming coal, or whatever the interest is. And this vehicle gives them an ability to create an entity that allows them to conduct that business a little bit differently, with duties that are a little bit different from a traditional corporation.
Representative Hunt.
Thank you, Mr. Chairman. On page 3, top of the page, Romanet 2, when we're defining what a public benefit is, how do you separate, I guess, what does I mean, we've got our definition spelled out here, but if you already, for example, because it says effects of an artistic, charitable, et cetera, literary, blah, blah, blah. But if you're already an art studio, if you're already a publishing company, if you're already some sort of private medical firm, how do you distinguish between your for-profit efforts and what would be considered a public benefit to the greater good?
Mr. Cobb?
Mr. Chairman, thank you for the question. So I think the first part of that would be if an entity is already existing and already has, right, business activities to generate a profit, and they want to become a public benefit corporation, they're going to have to convert. They're going to have to legally file documentation with the Secretary of State's office and take the legal steps necessary to convert to where they can have a public benefit corporation standing. The second part of that question, though, I think is if an entity has an existing business line and now they all of a sudden want to have some other outside, or I keep referring to it as an extrinsic purpose or value that they want to take into consideration. Again, I think they can do that. They can add that to the mix. It's much more difficult, though, for traditional corporations to do that.
Yep, go ahead.
Thank you, Mr. Chairman. Not so much of a follow-up directly to that, but over on page 6, with under the duties of the directors, and we're saying on line 17 that balances the pecuniary interests of the stockholders and the public interests identified. I guess when we're saying balances, are we talking to try and strike a balance literally of 50-50 between the interests of the stockholders and the public benefit? Or I guess what is ultimately prioritized at the end of the day, the interests of the stockholders for profit or whatever the charitable component is?
Go ahead.
Mr. Chairman, again, great question, and thank you for that. So I think the language here is intended to create sort of a scale, and you could be one end of the scale or the other. If a company truly has benevolent or charitable purposes, probably their first choice is going to be to consider being a nonprofit. But again, it's not always a black and white answer for these entities, and at some point in time, it makes sense for them to be a for-profit. So the statute isn't intended to create a perfect balance, a 50-50 balance. It's not even intended to prescribe what that balance has to be. It's giving the directors the option and the ability just to weigh. We both have pecuniary interests, and we also have these extrinsic, right, interests that we're going to try to balance. It's up to the directors to find that balance.
And Mr. Chairman, I would
Yes.
just quickly tag on to that. How do you strike that balance and how do you define the striking balance? I think the other parties that help define that are the individuals who have the ability to bring an action against the director, right, for violating it. So at some point, one individual or a collection of individuals believe the balance is broken, whatever that may be. In their mind, they may think it's 51-49 or 50-50 or 60-30 or 60-70, sorry. So they bring the action, and the end result is litigation in court where, over time, I think based on what these entities typically do in Wyoming, how they typically balance them, will eventually evolve a case law to that percentage. I think it will become more concrete over time.
Thank you, Mr. Chairman, and this is directed at anybody, but so is there a portion that either adds liability or shirks liability, being adding liability for your public duty or benefit duty, or shirking liability for profit? Is there a portion that speaks to that, or?
Mr. Olson, if you know, Representative Olson, or do you need to restate the quote? Go ahead. You got that.
I think so. I'm going to kind of restate it to make sure I got it. Mr. Chairman, through you, Representative Clausen. So you're asking if an individual has a public duty, but I think that we're not necessarily talking about a public duty in the sense that we're talking about the public duty that you have or that maybe Representative Hunt has on the boards that he serves on. We're talking about whether it is a public benefit. So whether it has a beneficial purpose to the public. That does not in itself, I think actually the statute says it does not create a duty to the public. I would argue that that's what it says. So I think that the statute clarifies that.
Follow up, Reverend Clausen?
I follow, so that was close, but so if you're a director, does this, do you give up a little bit of liability if you enter into this sort of a corporation versus a regular corporation?
Representative Olson?
Mr. Chairman, Representative Clausen, yes. I mean, that was I think the explanation that Mr. Kaufman was giving in his introduction is that in a typical corporation, I have liability from my stockholders if I don't pursue the best interests of my company. So my best interest of the company being profits. And so now I do shield myself from some liability because now I can pursue both the profits and the benefit, the public benefit that is the purpose of my corporation beyond a profit. And I shield myself from that type of liability that may result simply because I wasn't pursuing the highest profits for my company, but I was pursuing the beneficial good of my company.
And your shareholders would get to decide whether that public good is
Yeah.
warranted or they can move on.
Exactly, Mr. Chairman.
Senator Rothman's add on?
Thanks, Mr. Chairman. Just to add on to that, and I believe Mr. Kaufman gave the example of the East Coast Wheat Company that prefers to buy only domestic wheat. And I think it's a good example for Representative Clausen's discussion where that isn't necessarily going to be in the best financial interest at all times for that company. So by being a public benefit corporation, they can make that option. And they've declared that as part of the public benefit of their purpose. That's going to be part of their articles and indicate that's their intent. And so at that point, they will not have liability to their shareholders for not optimizing the process with regard to that. And I think that's an important characteristic is you would not be completely removed from having any obligations of any sort. You need to be expressing your public benefit and you need to characterize some of that. But with the balance there between the pecuniary and the benefit purpose, it provides more flexibility than you would otherwise have.
Representative McGuire?
Thank you, Mr. Chairman. I think that we need to clarify just a little bit. There have been a lot of statements about duties to shareholders and ultimate profitability and everything. The board of directors has a broad range of direction that they can take a company in. And there are companies that have never shown a profit, that are entirely devoted to developing new technology. There's a car company that has never shown a profit. So let's back off on that just a little bit. And yes, there are duties that the board has to the shareholders, but those are very well balanced and it's at the direction of the shareholders and the board. And so let's just kind of keep things in balance a little bit. Thank you. Wouldn't you agree, Mr.
I was
Chairman?
going to say, I may have missed the question, Mr. Chairman.
When
Yes, I will agree.
They agree. So I just want to make sure there's no, on the Secretary of State's office, this doesn't change any type of filing fee, anything that they have to do. You basically get to elect when you form a corporation, otherwise that you are a for-profit public benefit corporation. And that's why that we call it a supplement to our laws.
Mr. Chairman, that's correct. Much like we already have the closed corporation supplement for corporations, when you file a corporation, you can elect to be a closed corporation. This would be the same type of election.
Because I know you know this question is coming because it's a great idea. And I thought I covered it 10 years ago when I brought the L3C. What is the difference in a for-profit public benefit corporation versus a low-profit limited liability company? Besides, is it just not being sued by your shareholders? I mean, is it another maybe too basic, but that's the primary purpose?
Mr. Chairman, great question. And I think the simple answer to that question is no one is using nationwide low profit limited liability companies because it's a pass-through tax vehicle, whereas corporations are taxed on their own. And so the election is clear in the market that people prefer to have these entities be a corporation.
Tried so hard. It was a great bill a decade ago, committee. I thought it was revolutionary and then no one picked it up. Representative Aarp.
Thank you, Mr. Chairman. I suppose it's pretty obvious, but I'll ask this question anyway. Would you anticipate this being a vehicle to make investment in certain companies more attractive to investors?
Mr. Kaufman?
Yeah, Mr. Chairman, Representative, yes, I do think so. Again, in that vein of keeping Wyoming competitive, where we have all of the tools available in the toolkit, this is another one of those vehicles that's very attractive for certain types of entities. To Representative McGuire's point, is it suitable for every company? No, absolutely not. But there are, those types of companies that do strive to take into account some extrinsic value or benefit. And for those companies, this becomes very attractive and very useful.
Well, thank you. How specific does that public purpose have to be? I mean, could you say we want to promote goodwill and kindness, or I guess it's up to the stockholder or the corporation, but
Yeah.
Mr. Kaufman, or do you have any examples besides a bread company, anything else out there that a name brand we would know?
Mr. Chairman, Patagonia is a public benefit corporation. Now, they have a public benefit that might not necessarily be one that I would choose. They're more environmentally oriented. But there are lots and lots of public benefit corporations out there. I do want to make one quick distinction just for the committee, in case anybody researches this or looks up on their own. There is an entity out there called B Labs, and B Labs is its own entity that has undertaken to certify companies as what they deem to be a benefit corporation. Has nothing to do with a legal entity status that you obtain by filing with the Secretary of State's office in a particular state. So B Labs has gone out there, and companies can apply to B Labs and say, we want to be recognized by you as a benefit corporation. All that means is that B Labs, this company, finds that you have some purpose, some mission in your company that is a good thing. So I just wanted to clarify that point. This has nothing to do with the B Lab certification. This is a legal entity filing.
Okay, any further questions at this time for any of the presenters? Don't go too far. Let me see if there's any public comment. Anyone here in the audience here to testify on Senate File 36? Anyone online wish to testify on Senate File 36? I'm guessing they're all here for the PSC bill. Wildly popular concept. Not a single person can testify, huh, Mr. Kaufman? I'm not seeing any public comment then, committee. Anything else you guys want to wrap up with? Senator Rothfuss, welcome.
Thank you, Mr. Chairman. Oops. I will say we did have public testimony in the interim and even in the Senate committee. I think this one snuck up a little bit on me. I realized it was a committee meeting last night pretty late, so I might not be the only one. With regard, though, to the purpose, there's a couple of things that really brought it through the blockchain select committee that I wanted to raise. And one is we did have folks in the blockchain community saying, well, we'd love to be able to set up in Wyoming and we love everything you're doing with blockchain, but we actually wanted to formulate around a public benefit corporation. And so we couldn't have let them do that. And the idea that we would exclude a corporation from Wyoming that can domicile in 36 other states, just because we lacked something on the books that seems to be popular, seems to happen, and seems to be reasonable. We thought it was appropriate for us to bring that forward. And obviously working with Mr. Kaufman and others allowed us to get that done. And he has clients that have been interested in it as well. So again, I don't know how many corporations will choose to domicile here because of this, but as we're looking at concepts in the blockchain select committee, there are a lot of these public interest groups that are contemplating corporate structures in blockchain and working with coin offerings. And we just wanted to make sure that everything was available, and we didn't see any reason why we would exclude this type of a corporation just because it wasn't on our books. And we certainly hope that you'd support this and move it along, just to make sure that we do have all of the arrows in the quiver that corporations are interested in utilizing and startups are interested in working with. Thank you, Mr. Chairman.
Let me turn my mic. With that, we'll close public comment. Representative Roscoe has moved Senate File 36, seconded by Representative Air. Any amendments committee you want to put on Senate File 36? Representative Hunt.
Thank you, Mr. Chairman. I'm wondering, on page 4, line 17, I would move to change the may to a shall, so that it would read that that they shall contain the words Public Benefit Corporation, or the abbreviation of PBC.
Is there a second? Seconded by Duncan. Barb, you got that, the made a shall. And I know we do have naming conventions in the Secretary of State's office on when you have to, add certain words and you can't. I'm just afraid of putting a shall in the law without knowing.
Mr. Chairman, and I guess the reason for my bringing that is I just think that if we're going to be transparent about it, that it should be required that just be front and center on the title should a company choose to, go this direction.
Okay, and then further on, it does say if they choose not to do that, they still have to put on their stock and shares notice that they are a for-profit public benefit corporation. I don't know if it's the biggest change in the world, but I just want to make sure we're not screwing up anything. Representative Eric?
Yeah, I'd just point out as well, up on line 8, it is a shall. So they already have to state that they have a public benefit. But it is a for-profit. I thought the may was just this PBC.
Instead of
I know.
saying LLC or corporation, they can say PBC instead of corp.
Yeah.
Other discussion committee. All those in favor of the amendment, please say aye.
Aye.
Opposed, say no. No. Show of hands. All those in favor of the amendment, raise your hand. I got 4, all opposed. Vote no. Okay, that amendment has not passed. Back on the bill. Further discussion or amendments committee? Seeing none and question being called. Barb, if you would call the roll on Senate File 36.
Representative Blackburn. Representative Clausen. Representative Clifford. Representative Duncan. Vice Chair Air.
Aye.
Representative Hunt. Representative McGuire. Representative Roscoe. Chairman Zwanitzer.
Aye.
7-2.
7-2, and Chairman Olson, I assume you're carrying this on the floor. Great. Thank you very much, Senator Rothfuss. Are we your first favorite committee? Not your own, huh? I can appreciate that. Good to see you, Chairman Olson. All right, committee, next up is Senate File 62, which apparently has a blue copy. I don't know how you take a one sentence and you change the date. It's always the simple bills that have the most fun. So we're working off in the engrossed copy, which just reappeals 37-2404B. This is actually brought by Management Audit. And so I would expect somebody from Management Audit to be here to present the bill, but I'm not seeing anyone.
So you know what that means? Bill dies.
No, all representatives need be.
Oh, do you want to present the bill? Chairman Air, go ahead.
Can I do it from here?
You can certainly do it from there. We have like 9 people to testify, so you don't have to do too much
Okay.
work.
Well, this bill is very simple. Yeah, there was a sunset date on the Office of Consumer Advocate, the OCA, if you will. And the original version of the bill was just to extend it another 5 years. Senate amended it to just repeal the sunset date altogether, which I think was a really good move. We are vesting more and more requirements, more and more duties on the Public Service Commission. The Office of Consumer Advocate is a bit of a, they're there to look out for the well-being of the ratepayers in the state. And it's a highly technical, highly complicated field that they deal in, and they need to have longevity, they need to have certainty, they need to know that they're going to be in existence on an ongoing basis. And I think it just improves the ability for them to attract qualified people if they know that there is no sunset date, that they can be here forever. And they're a needed organization in our state government. So
Good enough. Questions for Representative Air? Representative Roscoe?
Thank you, Mr. Chairman. Representative Air, do we know how much it costs the state for this office?
Hey, Mr. Freeman, you might as well come on up now.
I don't know that, but I know there's someone who does.
Thank you, Mr. Chairman.
And so, Mr. Freeman, well, you can certainly introduce yourself, but you are the Director of the Office of Consumer Advocate, last I knew, correct? And so certainly, if you have thoughts without lobbying, you're welcome to share any thoughts you have on your office, if you'd like.
Thank you, Mr. Chairman. And thank you, Representative Air, for introducing the bill. My name is Bryce Freeman. I am the administrator of the Lyming Office of Consumer Advocate. I've been the administrator since the office was formed. Representative Air is quite correct in stating that what we do at the Office of Consumer Advocate is not rocket science, but it's pretty close. It's a very complicated area. We have to have expertise in accounting, finance, economics, engineering, operations, all of those things. And we're a small office. There's only 6 of us. There's 4 of us, including me. I am a working rate analyst, so we testify as witnesses before the State Public Service Commission. We also have 2 attorneys. And so our mission, and I'm probably telling many of you things that you already know, but just for those who maybe don't know, our mission is to serve. We serve the public, we serve the ratepayers of the state of Wyoming, and we serve the Public Service Commission. It's our job to present evidence, fact-based evidence to the Public Service Commission so that they can make informed decisions with regard to public utility issues. In many cases before the Public Service Commission, we are the only intervener. So there wouldn't be any other place for the commission to get evidence to base its decisions on. In other cases, we are a party, and there are other parties in the case that have different interests. They have their own interests to represent that don't necessarily coincide with the interests of the general public or the general body of ratepayers. So with regard to Representative Roscoe's question, we are not a generally funded agency. So the money that funds the Public Service Commission and the Office of Consumer Advocate comes from a gross revenue receipts tax on public utilities that is passed on to customers. Customers pay that. And we recently did some calculations and determined that it costs the average ratepayer in Wyoming about 7 cents per month to have us in their corner fighting for them. And, you know, what I hate to use the word fight. What we really do is provide a counterbalance to what the utilities want to do. And they have obviously a fiduciary responsibility to their shareholders. And when you understand that, you know, we're not necessarily, we don't hate the utilities, I guess is what I'm trying to say. They have a duty to serve their customers in Wyoming as well. They have a duty to provide safe, adequate, and reliable service. We often disagree about what the best way to do that is, but we can all work together and find the best way. Sometimes we can't. We're in a contested case, as a matter of fact, this week with one of the state's largest utilities, where we couldn't agree on the best way. And so the commission, we're bringing our evidence, other parties are bringing their evidence, and the commission will weigh that evidence and decide. But my mission is to ensure that they have the best evidence before them that they can, so that they can make the best decision possible.
So there's not a negotiated kind of settlement coming forward on this one, huh? Because historically, is it fair to say that many times a utility, especially some of the largest utilities, electric rates, and the OCA and others have kind of got together and bounced stuff back and forth, and you've presented, here's what we think will work to the PSC, but not in this case?
Mr. Chairman, not in this case, but in some cases, we do work with utility and other parties, and to the extent that we can arrive in a negotiated stipulation that gets before the commission, and the commission is not obligated under law to accept that agreement. We file it with them. They go over it with a fine-tooth comb. And to the extent that we support it as a group of parties as being in the best interest of the public, then they have the option of adopting the stipulation. They can also reject it, or they can modify it as well.
Other questions for Mr. Freeman? I believe we do have 3 or 4 people to testify. I know Ms. Throne has her hand up. Representative Ayer, another question? Mr. Freeman at this time?
No else.
Representative McGuire, go ahead.
Thank you, Mr. Chairman. So a question for you as to taking a look at the budget. So I'm looking at the white sheet, which still has the fiscal note attached. And it says the budget, give or take, is $2 million. 80% of that is fixed costs, which is personnel. It's listed as 6 people, plus some office space. I presume that that's state office space. So I'm just curious, is it possible, or can you tell us what the rest of the budget is? And one of my questions always is, if that money is going to out-of-state contractors or attorneys, or how much of that's flowing out of state? So thank you.
Sure. Mr. Freeman.
Mr. Chairman, Representative McGuire, about 80% of our budget is salaries and benefits and that sort of thing. We do have some rent that we pay. One of the interesting things regarding the office is that when it was created as an independent division within the Public Service Commission. So we don't take any direction from the commission. We run our own show because obviously when we get into a hearing, we want to be independent, and we want not to have, we want to be able to present evidence that wasn't directed by the commission. But for budget purposes, we share certain things with the Public Service Commission. We share IT personnel, we share payroll and administrative services. So we pay our share of that, but that avoids us having to procure that on our own, which would be more expensive. The building that we occupy, we have a small space on the same floor that the Public Service Commission leases. And they have, their hearing room, they have requirements and whatnot. So we've been in that building since 1996, I believe it is.
I think ultimately the question Representative McGuire is asking, do you have any out-of-state contracts, or do you do any other kind of 900 series, anything that, any of the rest of the money, anything interesting with it?
Mr. Chairman, Senator McGuire, yes, that I was going to get to that point. We do have a 900 series budget. It's about $240,000. Last year, I did not spend any of that money. It is there, and I have in the past when we've gotten to certain particular things that were beyond the expertise of our office to do. I have gotten some consultants in the past. The last 2 contracts that I had using 900 series money were with professors at the University of Wyoming that had unique expertise. But mostly I have a fabulous staff, and there isn't much that we can't do on our own, which is sort of unique among my peers across the country. A number of the offices around the country really have, if they have 6 employees, they have 6 attorneys, and they hire out everything else. We don't do that. We develop our own evidence and run our own cases so that we're thoroughly familiar with the issues that come before the commission.
Other questions, Mr. Freeman? As you can tell, he's done this a lot of times before the legislature, and that's why he's very, I wouldn't say defensive, but very thorough in his explanation because, yeah, it's a brand new day, Mr. Freeman. Certain legislators are no longer here who are going after agency to the level they were. Other further questions? Seeing none, Ms. Throne is in the room, former representative and minority leader. Throne, go ahead, Mary, you have the floor. You're still on mute though, Ms.
Usually I'm in the hearing room when we do this. I want you all to notice that I'm wearing my cowgirl colors today. I don't know what's wrong with all of you that you're not in your brown and gold, Mr. Chairman. But anyway, I'm happy to be here and just wanted to mention 2 quick points to supplement Mr. Freeman. First, in regards to the budget, we are not a general funded agency, as he stated, but our budget does go through the appropriations process pretty thoroughly. So we do an assessment, but we only do an assessment to collect the budget that's already been approved by all of you. And then the second point I wanted to make that I don't believe I heard Mr. Freeman mention is that even in the absence of an office of consumer advocate, we would have somebody fulfilling that function, which is how it was, as you will recall, Mr. Chairman, because I think you were in the legislature when the bill passed originally, or it was just before you started actually, that the independent office was created. And so the function was handled by staff. And so the problem with that is that people would be, one day they'd be PSC staff, and maybe in the next case, they'd be consumer advocate staff. And so this independent office was created so that you have a Chinese wall, so to speak. And all the bill does is, just give stability to what has been the system since 2003 or 2002.
I think it's 03 when it went into effect. Any questions for Commissioner Throne? And also Commissioner Petrie is in the room. I don't know, Chris, if you had anything you wanted to add to Commissioner Throne's testimony, since we have 2 of you. I'm not seeing. We'll start video later. Okay.
Sorry.
Oh, go ahead, Mr.
Chairman, I'm just here to answer any questions.
Okay. With that, we'll go to Mr. AC. Welcome, Bruce, to Corporations.
Thank you, Mr. Chairman. Bruce AC on behalf of Montana Dakota Utilities Company, and I need to point out to Commissioner Throne that I am wearing gold today in my office, so thanks for that shout out. On behalf of Montana Dakota, we appreciate the work of the Mr. Freeman and the Office of Consumer Advocate. They do perform a welcome and valuable service to not only the public, but to utilities. There are many times, quite frankly, where we may make a mistake, and upon being reviewed, it allows us an opportunity to correct mistakes and expedite the process and ensure that the commission is reviewing an appropriate product as we bring it to the commission. So we stand firmly with the OCA in asking that the committee move this bill forward. We think it's appropriate and vote for its approval. Thank you.
Thank you. Let the record show that MDU messes up every once in a while, apparently. Just kidding, Mr. AC. Any questions for Bruce? Seeing none. Always a pleasure seeing you. Mr. Laycock from AARP, welcome to Corporations.
Thank you. Much appreciated. My name is Tom Laycock. I'm the Associate State Director for Communications and Advocacy for AARP Wyoming. We consider ourselves to have a consumer protection bent a little bit in the state, and so one of the things you do. But the nice thing is the fact that myself and Sam, neither one of us really have a huge background in utilities. So the first thing you do is you get on the PSC list, and they send you all of your notices. And then you start reading them, you realize how technical it is. And really the one thing that I'm very pleased that the OCA has been able and willing to do is just offer themselves as a PSC to English dictionary for us. And so what you see in a lot of other states is organizations that have a consumer protection bent will really, they will engage on most any rate case whatsoever. And frankly, it's been wonderful for us to be able to call Bryce and his group and say, here's the latest rate change or proposed rate change. Is this reasonable? Is there a reason for it? Is this something we need to get in on? Or is this just kind of the cost of doing business? And to a case, they've been able to give us that answer every time. So we're certainly very appreciative of the work that Bryce and the OCA do. We're very supportive of this particular bill, and we're thrilled to see the sunset removed altogether. So that said, I'll be happy to answer any questions, but thank you for the time.
Any questions for AARP? Seeing none. Thank you very much, Tom. Always a pleasure seeing you. Any further public comment? Mr. Kaysen, you're just here to, okay. I'm not seeing anything else online. Committee, any further questions you have for any of the presenters? Seeing none, I'm stalling. Oh, all right, we'll close public comment. Committee, what is your pleasure on Senate File 62? Moved by Duncan, seconded by Clausen. We're on the bill. Anyone have any amendments? Representative Duncan.
Thank you, Mr. Chairman. Despite Representative Ayer's passionate plea, I would like to move to amend it back to 2028 on page 1, line 12.
Is there a second? Second by Blackburn.
Mr. Chairman,
Representative Duncan.
I just feel like after I found out that it's customer generated fees by rates, I just feel like 2028, we just need a little checkup. I think that's reasonable, rather than just an open-ended forever.
Okay.
That's it.
Real quick, Mr. Freeman, how many times have we extended the date? At least 5 that we've tried. I know it was 2023 and they tried to make it 2017 a couple of years ago. Then it went back to 2023. How many times have you been before the legislature extending your sunset date since you've been there?
Mr. Chairman, this would be the 4th.
Okay. Committee, another discussion? Seeing none.
I got it.
Yeah, yes. Representative Aarp, go for it.
Thank you, Mr. Chairman. I would resist this amendment. I think it's very important that the OCA have that stability and that longevity to attract the kind of personnel they need to perform their duties. I worked for a regulated utility back in the old days when the co-ops were regulated, and even before the OCA was created. And I always thought it was really uncomfortable for staff of the OCA or staff of the Public Service Commission to sometimes take a position that was a little opposite of what the commission themselves would have taken. And so I think it's important that we have that independence, that Chinese firewall, as Commissioner Throne mentioned. Chinese firewall, yeah.
Just Chinese wall. I don't think it's fire.
Chinese wall.
Much blockchain to that.
I think they need to have a surety that they're going to be a long time entity in our state government. And yeah, they do collect fees from the utilities based on their gross revenue, which gets eventually rolled into utility rates. But they have saved far more, multiple times. I would venture maybe hundreds of times the money that ratepayers pay through that public utilities service fee. So I think they're important entity and provide an important function, and they should be know that they're going to be in existence far into the future.
Representative Roscoe?
Thank you, Mr. Chairman. I would have to agree with my vice chair that having some longevity might also possibly provide better employees that they know they're going to be there for a while and educated in this field, that would stay there. And I think we would have maybe a better department if that's what it is. Thank you, Mr. Chairman.
Thank you.
Mr. Chairman.
Representative Blackburn?
Thank you, Mr. Chairman. So with that being said from the last speaker, I wonder how much turnover they have had. Can we get Mr. Rice to address that?
Mr. Freeman, of the 6 employees you've had now for almost 20 years, what's your turnover rate been? I know Ms. Parrish was there forever and just retired finally a couple of years ago. Go ahead.
Mr. Chairman, actually, our turnover rate, I would say, over the course of the OCA's existence hasn't been phenomenal. We have had some turnover rate in, as you mentioned, in the last year. I did lose 2 longtime rate analysts, and I was fortunate enough, thank the Lord, to find a couple of brand new rate analysts that have been very quick studies, really didn't have utility backgrounds, but have taken to utility regulation like fish to water. And so the turnover hasn't been a big problem, but I think it, it could be. And frankly, my guys worry about whether or not the sword of Damocles will actually fall at some point.
Further discussion on the amendment. So again,
Question.
the amendment is to take the full repeal back to a July 1st, 2028. All in favor of the amendment, please raise your hand. All opposed to the amendment, raise your hand. Okay, that amendment has failed. A lot of 5-4 votes today, committee. All right, further discussion on the bill. Seeing none and question being called. Barb, if you would call the roll.
Representative Blackburn? I'm sorry. Thank you. Representative Clausen? Representative Clifford? Representative Duncan? Vice Chairman Air? Representative Hunt? Representative McGuire? Representative Roscoe? Chairman Zwanitzer? 7-2.
So committee, I will check with the Management Audit Committee or whoever was chair of the Management Audit Committee last term. I don't actually know who was, to see if I'm presenting or they're presenting the bill on the floor. I think you're all aware. Thank you, Mr. Freeman, for being here and everyone presenting. No. I know you've been getting quite a lot of emails from multiple groups about the bills coming up in Corp. I believe might only have Wednesday, Friday, next Monday for our last 3 meetings. And Wednesday, we're going to do athletic trainers and the 2 licensing bills and physician assistants. And then we may get to Senate File 16, which you've been getting emails about for 6 weeks at least, and some of you 2 years. And then there are some other bills in the Senate that I know have been very prolific in the public. And if they come to our committee, we would hear those next Monday. So Representative Air.
So did you say if time allows on Wednesday and then on Friday, or just Friday probably?
We have 3 bills up Wednesday plus 1 if time allows. Those are our interim court bills besides Senate File 16, but we are doing the co-op utility bill deposits. And then Friday, we'll probably do the 15, not whatever that was. I'm remembering numbers and not names. But the Senate, I think, has 7 bills from Corp that may still come over to our committee. So I'm just letting you know we're going to be a very full committee the next 3 meetings. Representative McGuire.
Thank you, Mr. Chairman. Will the Office of Consumer Advocate be here to navigate us through the Senate File 16 conundrum?
Mr. Freeman, if we hear Senate File 16, we would welcome you back to come visit and join in the fun of
With an opinion. With an opinion.
to advocate on behalf of consumers in Wyoming if you think that's a good bill or not. I guess we're prepping you now that you might want to have thoughts and prepared. Okay. All right, with that committee, if there's any bills you really want me to move up to Friday or you want me to delay back till Monday, send me privately and we'll be adjourned until Friday at